commercial code. That's very similar to validation of debts. That's one of the things I haven't talked about on the podcast. I've only talked about it in consultations, but we're going to talk about 1692G. 15 USC 1692G, validation of debts. So basically, the section 1692G, whenever you're writing your debt validation letter, which is part of your administrative process, you're basically letting them know what they have to do to actually validate that debt. But even though you're reading the 5 things that they have to do to validate the debt, understand that they cannot validate the debt. Only you, the consumer, can validate the debt. So just keep that in mind as we're going through. Notice of debt, contents. Within 5 days after the initial communication with the consumer in connection with the collection of any debt, a debt collector shall, unless the following information is contained in initial communication or a consumer has paid the debt, send the consumer a written notice containing. Number 1. Oh, before we even continue, like I said, as y'all are going through it, if you want to tag me on your story or something, let the people know what you're doing, let the people know, you're getting the information, go ahead. So number 1 says the amount of the debt. So number 1, they have to say the amount of the alleged debt. Remember what I said about the hyperlinks. When you click on the hyperlinks, it lets you know, it takes you back to the definitions. So the term debt means any obligation or alleged obligation. So get in the habit of clicking on them hyperlinks. So let's go back. They have to let you know the amount of the debt. Number 2, the name of the creditor to whom the debt is owed. Number 3, a statement that unless the consumer within 30 days after receiving the notice disputes the validity of the debt or any portion thereof, the debt will be assumed to be valid by the debt collector. So I have to let you know that too. Number 4, a statement that if the consumer notifies the debt collector in writing within the 30-day period that the debt or any portion thereof is disputed, the debt collector will obtain verification of the debt or a copy of a judgment against the consumer, and a copy of such verification or judgment will be mailed to the consumer by the debt collector. And number 5, a statement that upon the consumer's written request within the 30-day period, the debt collector will provide the consumer with the name and address of the original creditor if different from the current creditor. So I'm gonna give you all a secret. All 5 of these things, these debt collectors are never gonna give it to you. But like I said, even if they give it to you, the language is very, very important. Even if they give you the 5 things, what does debt even mean? Any obligation or alleged obligation. If it's an alleged obligation, even if you give me the 5 things to actually satisfy or validate the debt, it's still an alleged obligation. I wrote to you, it's an alleged obligation. So it's an alleged obligation. That's the foundation. So really just understand, even if they send you the 5 things, which they won't, it's an alleged obligation. We're gonna walk through my affidavit example. It's an 11-page affidavit. It's asking more than like 50 questions, basically. So you have 5 here, but in the affidavit that I send, it's like 50-something questions. They're not gonna answer every question. So by law, your affidavit is your most important piece of information when it comes to, winning in court and all that. So by law, that affidavit is going to stand true, because if it's not replied to line by line, it stands as true. So yeah, just keep that in mind as we get into the affidavit. I'll give you guys more information on that. But the validation of debt section, this is basically what they say has to be satisfied. And like I said, I'm going to give y'all a UCC code, Uniform Commercial Code, because, these laws go deeper than 15 USC. There's UCC codes, there's rules. Rule 1, Rule 2, Rule 602. We're going to go through some rules as well, which I don't talk about on the podcast, but I'm going to, y'all pay for the class or replay, so you'll get the information. But yeah, don't get overwhelmed. It's a lot of information. Just be taking notes and then revisit it later. Just take action. So B, 1692G, number B. I said number B, letter B, disputed debts. So this is a long paragraph. I'm not going to read the whole thing, but basically all you need to know is that if you notify the debt collector in writing that the debt is disputed. So if you're disputing a debt, it means that they're not supposed to attempt to collect on it. So basically, when we go back to 1692 CC, which is season communication, if y'all took notes or just remember, that was basically where we were talking about. Once we let them know that we refuse to pay on the alleged debt, they have to cease communication. They have to stop communicating. They have to cease their collection efforts and cease communication. 1692G B is an additional ceasing communication section. And I'm also going to give y'all later, it's going to tie to multiple debts. Whenever you dispute a debt and they've received your notice and it's noted that you're disputing a debt, you can use 1692H, which is multiple debts, and you can actually send a notice to invoice them for previous payments. Because if they are attempting to collect on a debt that is disputed, that's a violation. So we're gonna dive deep into it, and it's gonna tie to the Fair Credit Reporting Act. This is a specific section in the Fair Credit Reporting Act. So yeah, so if you're disputing, they're not supposed to attempt to collect on it. Just remember that. 1692G(c), admission of liability. The failure of a consumer to dispute the validity of a debt under this section may not be construed by any court as an admission of liability by the consumer. So this is basically saying that if you fail to say that the debt is yours, it shouldn't be misconstrued that you're liable for that debt. So what does that mean? Isn't Congress looking out for you? Congress is looking out for you because usually it's like ignorance or the law is no excuse. But the fact that they're saying that if you fail to dispute the validity of it, it shouldn't be misconstrued as saying in court that you do owe that debt. So Congress gave you all the power. They gave y'all a cheat code by saying that even if you fail to say, oh, this ain't my debt, they can't say like, oh, you didn't say it's your debt, so now it's your debt. Admission of liability. So 1692G(c), that's a powerful section as well. Pay attention to that one. So that's pretty much validation of debt. Like I said, I'm going to give y'all an additional validation of debt UCC code. But that is that. Any questions? Any questions? I've been talking. I need a water break. I